Now they are not being able to purchase the properties. So one of the major litigations going on as on today is specific performance. But before I go on to the next aspect of this webinar, I would be dealing with one last aspect, which is very, very important. Whether the time is an essence of a contract whenever an agreement is executed. Now, court has not initially, the courts were generally having, Supreme Court was dealing with this aspect that in a specific performance court, time is not never a sense of a contract. But with today's world, amount having been involved into crores of rupees, Supreme Court has gradually changed and says that time is always a sense of a contract. However, it is upon the other party to prove it was not a sense of a contract from the circumstances and facts of the case. So in these circumstances, if time is not in a sense of a contract, then the reliefs are modified by the courts. But if time is in a sense of a contract, and due to any reason, either the plaintiff or the defendant, they falter somewhere, then the specific performance is refused. Now, just a passing reference to an incident. If I was to purchase a property for 2 crore and I have mentioned in the agreement that this 2 crore money has to be paid by within 1 month, as I have to purchase a property further, which is agreed to be purchased, in this circumstances, time would be in a sense of a contract. Even 1 day delay by the plaintiff would be fatal for the defendant because he has to purchase the property, and the court will refuse specific performance in such a case. But because we have a limitation to file a civil suit for specific performance from the last day of the agreement date, I will say, that is 3 years. So if a person files the case after maybe 2.5 years and time is in a sense of a contract, his suit is going to fail. Then his conduct is also taken into consideration by the courts to reach to a conclusion whether he was having any right in the property or not, to get it specifically performed. In those circumstances, whenever it was dealt with, so the court would ultimately hold that why did you wait for 2.5 years to file the present suit when you had a right to file the suit within very second day of getting the presence mark before the sub-registrar. So you have to explain the delay, you have to explain the circumstances, you have to explain and prove the time was not in a sense of contract, so I could have delayed it. So in these circumstances, this is how we have to deal with suit for basically partition initially and suit for specific performance. Now, suit for challenging of wills. We all know what is a will. Will is a testamentary right given by a deceased whereby he has in fact bequeathed the property even to a stranger. And it is a right being given by a person to his legal heirs as to how the property is to be divided after him. Now, if there is no will, the governance of the law would be followed. Like Succession Act, Hindu Succession Act, Muslim Succession Act, other succession acts are to be followed. But where once a will is made, in those circumstances, obviously somebody would be given a prime property, some may be debarred, someone may not be even given anything. So, or somebody who has been given less property, but he was saying that he was looking after his father a lot, or mother a lot, or anybody. In those circumstances, he would have a right to file a civil suit, either to challenge the will or get the will proved. Now, Section 34, kindly note down. Section 34 is basically a suit for declaration under specific relief act which has to be dealt with. Now, wherever you are challenging a will after the death of the person, that a testator, you will have to file a suit for declaration. Now, suit for declaration is to be filed in 2 ways. Generally, as a legal person, I would only, if I am not in the knowledge of a will executed by my father or anybody who has given the property to me, I will file a suit on the basis of natural succession, asking for a declaration, and make all the legal heirs as a party, and one of the legal heirs propounds a will. He comes up with the plea in the written statement that my father had executed exclusively will in my favor, and he says once he is propounding a will, an issue would be framed by the court whether the will was duly executed. Second issue obviously generally would be whether the will is surrounded by suspicious circumstances. Now, execution of the will legally has to be proved by the propounder always. He has to prove the will as per provisions of section 68, 69, 70, 71 of Indian Evidence Act. Will is a very important document which is compulsorily to be tested by two persons. And it has to be proved specifically as per sections 68, 69, 70 and 71. There are allied provisions to prove the will. Now, execution of the will is always to be proved by the person who propounds the will. But the will, if it is surrounded by suspicious circumstances, it has to be in fact explained by the person who is challenging the will. Now, there are two ways to challenge the will. One, if you challenge the will saying that the will is forged and fabricated or impersonated or not never executed by my father or by the testator, in those circumstances, initial onus would always shift upon the person challenging so. He will have to prove that why the will has been forged and fabricated, why it is not executed by the father, and then thereafter the onus will shift upon the other party to show that they have the will which has been duly executed. Now, in those circumstances, obviously section 68 is the basic way how to prove a will. If 68 witnesses are not available, both the witnesses, then 69 will come into picture. If 69 is also not available, then section 70 and 71 will come into picture. And you will have to prove the will. Now, if the will is ultimately proved, and still you have to challenge it by saying that it was undue influence, it was not in a correct mental state of the testator. In those circumstances, you will have to prove the suspicious circumstances which would come out as to how the will has not been properly executed. Now, this is a very tricky situation. The will is duly proved to be executed, but the will is surrounded by suspicious circumstances. The person who had executed the will was a person of unsound mind, or he was having undue pressure upon him by the person who is a beneficiary, and he was not in a proper state of mind to execute the will. Or there are other suspicious circumstances like his signatures are not at the right place. All these things are to be proved by the person challenging the will. He will have to prove that man was in fact not in a proper state of mind. He will have to prove that the person was mentally unfit. He will have to prove that this person basically who is executing a will, he was under undue pressure by the beneficiary. So all these things would come into picture and you will have to prove. In a suit for declaration, an injunction can be sought. So all these circumstances where you will have to show. Now let us presume we have come into picture. During the course of our practice, we always take a defense that this will has been executed after the death of the deceased. Maybe he was having the signatures on some blank papers. Now, will, we all know, is not a compulsory registered document. An unregistered will can also prevail over a registered will provided the execution is duly proved and there are no suspicious circumstances. So, in a case where unregistered will is propounded, there the person who is propounding unregistered will have to prove the execution and he will have to explain the circumstances which have been put forward by the other party which they claim to be suspicious. And mind it, this is for the remembrance of all the young lawyers or maybe even the elder ones like me, that mere registration of a will, mere execution of a will, proof of thereof will not make the will foolproof to be taken into consideration. If there are suspicious circumstances, the court can discard the will and say that this will is not in any stage admissible because no doubt execution is there, it is a registered will, but the will was surrounded by suspicious circumstances which have not been explained by the. Now, some of the suspicious circumstances are that if a will is being executed by a person living in Delhi and he goes to Calcutta just for the execution of the will, this suspicious circumstance has to be explained by the person that why it was being executed in Delhi, what was the reason, not in Delhi and in Calcutta or maybe in Bombay. Similarly, the witnesses in the said will were not known to the deceased. So why he would always put these witnesses? Why will he depose his faith upon a witness who is not known to him? So these type of things, these type of circumstances are to be explained. Generally, a question arises: what would be a fate of two different wills executed by the same person at different times? Well, legally, the basic aspect is that the last will would prevail, provided the last will is duly proved to be executed and does not have any suspicious circumstances. So a person has executed 4 wills. It is the last will prevail. But if the last will is suspicious and forged or maybe something else, then one will prior to that, and accordingly we go behind, the will would be deemed to be good. Now there are many cases where court discards the will because the wills have been propounded by different legal heirs and they have not explained as to what were the circumstances of an old person or maybe a young person to execute different wills, and without even mentioning the execution of the previous will in the last will. So it is always very nice whenever a person has to execute a will, because as a legal person we have to come deal with the clients who want us to execute the will and even be a witness. So we should ask our clients as to how many wills were executed before him, to whom he wants to give the property, and the reasons as to why he's debarring the person. Like it would be, if no reason is mentioned, a person is having his wife who is dependent upon him, and he does not mention in the will that he is debarring his wife for what reason. Then in those circumstances, it will be a suspicious circumstance, because every prudent man who is having love and affection with his wife will obviously want to make her future secure after his death, and thereafter would always want her property to go to his children. Now, in these circumstances, if there is no explanation as to why he is debarring a person, that would be a suspicious circumstance to be explained by the person who challenges the will, or maybe the executor also. So in these circumstances, there are various instances where wills are to be dealt by the persons, and once wills are to be dealt by a person at different circumstances, then in those cases, wills would be only upheld when 2 reasons are proved. Once, due execution. Second, all the suspicious circumstances are explained. Now, a question arises. This is a case where you have to challenge a will. Now, if a defendant propounds a will in a suit for natural succession, in those circumstances, it is the defendant who is propounding a will. Even if the will has not been managed in the plaint, you can challenge the will in the replication, because a new circumstances come in the written statement. As a plaintiff, you were not knowing that there was a will in his favor, and once he propounds a will in the written statement, you can challenge the will in the replication by mentioning that the will has not been duly executed and what are the suspicious circumstances in the said will. So as a lawyer, I would always say, whenever a person propounds a will, before filing replication, you should have a copy of the will with you. You should get it produced by the other party, read the will, see how it is suspicious, see about the signatures, see about all the documents, and once you have seen it, then challenge the will in the replication and get an issue framed with regard to the will. And once issues are framed, then ultimately litigation will go. Obviously, the person who propounds the will prove the will to be duly executed and explain the circumstances which are suspicious. While the person who is challenging the will, he has 2 ways to challenge it. One is challenging the execution. Second is to explain by mentioning the suspicious circumstances in the will. Now, this was the third aspect which is to be dealt with, and make your notes and you have a right to ask me questions later on. Now, third is not with regard to a civil suit which I am going to deal, because it is only with regard to identity of a property. Now, identity of a property is to be dealt with in a different way. There are basically 2 ways to identify the property, because if we see, let us exactly go to the thing. Deciding boundaries of a plot is the exact word. Now, topographical description is always there. Like who is on the northern side, who is on the southern side, who is on the eastern side, and who is on the western side. That is one way to deal with the property. Second, what is the municipal number given? or what is the panchayat number given, what are the official numbers given by the government. So in those circumstances, that is the second way to identify the property. So these are basically urban properties. Now, we have all heard about Jamabandis and Khasra Gadabris, and we have heard about the Khasra numbers also. That is how you have to identify the property of semi-urban or maybe even rural properties. Now, when these Jamabandis and Khasra Gadabris came into the picture, you would be astonished that wherever you are sitting, nearly 85% of the properties in the world have specific Khasra number. The and that is the red line. So these are different words being used at places. So once that is to be dealt with, that is a property which was always residential when the so-called property was to be taken into consideration. Once the people started identifying the land, they left the residential property to be called with the property within the Lalaki. And then they started defining every property by way of Khasra numbers. So every property which was beyond the original demarcation of the residential areas, this is how you demarcate the property which is rural and maybe semi-rural, or maybe the property which has been dwelt till last 100 years. But then once you are into urban properties, then you are to be bound by the boundaries. And what are the boundaries? I have already stated. The topographical description, the numbers which have been given by the municipal corporation, and of course the demarcation to be given by the revenue authorities with regard to the property in question. So once you have to file a civil suit, you have to very specifically mention for which property you are filing a suit. You should have to mention a number of the property, that is a municipal number or any other number. If it is Khasra numbers, mention Khasra number, plus mention the topographical description and attach a site plan with the civil suit, so that the ambiguity of the property is not one of the defenses being taken by the other party. That the property is exactly which was to be sold, or which was to be partitioned, or which was to be challenged. So that ambiguity in the property is one of the main defenses taken by the defendants when a simple suit for declaration is filed with no definition of the property. Now, whenever you have to file a suit, you have to specifically mention the number. You've got Khasra numbers, mention Khasra numbers, and then the topographical description, the description of the property with regard to sites. Now, in an urban property, it is the topographical description which is taken into consideration much better than Khasra numbers, because it is very hard to demarcate the property which has already been constructed. There are specific pakka bannas which cannot be taken into consideration. So in those circumstances, whenever the things are being mentioned by you by mentioning topographical description or municipal numbers, the property can be easily ascertained, and the courts would have much easier time to pass a decree with regard to that. So I hope I have been able to explain everything, whatever little experience I have gained with my life and due to my practice, and I am ready to